The share purchase agreement, or SPA, is the cornerstone of any M&A transaction. In Vietnam, drafting a well-structured SPA that aligns with local laws and business culture is critical to securing your investment and avoiding disputes. Many foreign investors rely on templates from other jurisdictions, only to discover too late that they are unenforceable or non-compliant. In this video, we show you how to draft an SPA tailored for the Vietnamese market and what legal elements must be included. The SPA is the definitive agreement that governs the sale and purchase of shares in a target company. It sets out the terms of transfer, representations and warranties, price and payment mechanics, closing conditions, and remedies. In Vietnam, the SPA also plays a vital role in regulatory filings and must be drafted with precision to meet both commercial and legal requirements. Start by identifying the buyer, the seller, and the target company with full legal names, addresses, and corporate registration numbers. If one party is a foreign investor, confirm that their status and investment vehicle are clearly described. Ambiguity in party descriptions can cause issues during notarization and registration. Also, clarify the number and class of shares being sold and the post-transaction ownership structure. Deal structure and purchase price terms. Clearly state whether the transaction is for all shares or a partial acquisition. Define the purchase price, currency, and payment schedule. In Vietnam, payments from foreign investors must be routed through licensed capital accounts. SPA should reflect this and include compliance language. Include any escrow arrangements, holdbacks, or deferred payments, with timelines and conditions for release. Conditions precedent. List all conditions that must be fulfilled before closing. These may include regulatory approvals, due diligence completion, third-party consents, or changes to the company charter. Conditions precedent must be specific and measurable. Include a long stop date after which either party can walk away if conditions are not met. Be realistic with timelines, especially when dealing with Vietnamese regulators. Representations and warranties. This is the risk allocation section of the SPA. Sellers must represent that they own the shares, the company is properly incorporated, licenses are valid, taxes are paid, and there are no undisclosed liabilities. Buyers should include warranties covering corporate structure, contracts, labor, litigation, environment, and compliance. In Vietnam, this section should also cover social insurance, land rights, and financial records. Avoid overly broad language. Be specific to the business and the risks. If certain risks are identified during due diligence, such as tax exposure or unregistered IP, include indemnity clauses requiring the seller to compensate for these items. Set caps and survival periods for claims. In Vietnam, parties often agree to 1 to 3 years for most warranties, with longer periods for tax and title. Consider establishing an escrow account to fund indemnity claims. Define claim procedures, documentation, and dispute resolution clearly. Between signing and closing include covenants to govern how the business will be managed between signing and closing. These may include restrictions on new debt, asset sales, hiring or firing staff, or changing the charter. This protects the buyer's position if closing is delayed. Include obligations on both parties to cooperate in regulatory filings and closing preparations. Closing mechanics. Outline the location, timing, and conditions for closing. List the documents to be exchanged, such as share transfer instruments, board resolutions, charter amendments, tax payment evidence, and updated enterprise registration. In Vietnam, closing is not just a signing ceremony. It involves physical document submission, regulatory processing, and sometimes notarization. Closing mechanics must match local procedures. Foreign investors often prefer to apply foreign law and international arbitration. However, in transactions involving Vietnamese companies, certain matters such as charter amendments or licensing must comply with Vietnamese law. Choose governing law carefully. If using arbitration, specify the institution, location, and language. Clearly define remedies, including specific performance or injunctive relief if needed. An effective Vietnam-ready SPA includes detailed appendices, shareholder list, licensing register, list of material contracts, IP schedule, financial statements, and employee roster. These schedules support representations and help both parties understand the company being acquired. Inaccurate or incomplete schedules can become grounds for warranty claims. At LTS Law, we draft SPAs that are not just legally accurate, but commercially practical and regulator-friendly. We integrate Vietnamese law, align with regulatory requirements, and protect our clients' interests with clear, enforceable language. We also guide clients through negotiation, localization, and post-signing compliance. Whether you are the buyer or seller, we help turn SPA terms into legal security. Planning an M&A transaction in Vietnam? Let LTS Law draft your SPA the right way. Visit lts.com.vn to schedule a consultation with our M&A legal experts. In every deal, your SPA is your shield. Make sure it is legally strong.